last week, at the end of last week, Hobson's Pledge said that the Treaty Principles Bill is a significant disappointment to them, and that this does not go far enough in meeting the concerns of ordinary New Zealanders. Joining us to talk about that, trustee of Hobson's Pledge and former leader of the opposition, Don Brash, joins us. Don, welcome to the show, and thank you very much for joining us.
Thank you, Michael.
You might have heard David Seymour with Sean this morning, yeah?
Yes, I did, yep. Mm-hmm.
In which he explained the Treaty Principles Bill and all the background and and the basis of it. And but you, as in Hobson's Pledge, have a problem with the bill. In specific, what's your major objection?
Well, let me go back. I mean, we're strongly in favour of the original Treaty Principles Bill that David Seymour talked about. It's very straightforward, and to us, it's totally consistent with what the treaty said. I understand your point of view about getting rid of the treaty, but of course it's an historical fact. It took place. Only question is, what does it mean in the 21st century? And Seymour was saying it means the Crown has the right to govern, and absolutely right, we agree with that. Two, everyone has the right to their own property. No one can object to that, I would have thought. And three, everyone is equal under the law. Now, that's the way Seymour understands the treaty. It's the way I understand the treaty. It's the way that New Zealanders understood the treaty for the 150-odd years. That was the interpretation which we all accepted as gospel. I say all, there must have been a few minor people around, or minority people, around who disagreed with that interpretation. But the great majority of people did understand the treaty in that way. And why do I say that? Well, we all behaved like that. We all accepted the government had the right to tax, the right to impose laws. We accepted that we would serve in the police and the army and the school teachers, etc. Those were all functions of the state, and all New Zealanders, be they Maori or other, accepted that was the role of the state, and they thereby acknowledged, indirectly at least, the Crown was sovereign and had the right to rule. Now, as I understand David Seymour's original proposal was, let's clarify that beyond doubt, because there have been doubts arising in the last 20 or 30 years that somehow those of the Maori ancestor somehow have additional rights which are different and better than other New Zealanders. And he's saying, look, as long as we believe that, we're in trouble. We've got to move to a situation where everyone has equal rights. And that was the purpose of this Treaty Principles Bill. Now, the Hobson's Pledge group strongly supports that. We believe that that's the interpretation of the treaty which makes sense. That's the interpretation which makes sense for the long-term future of New Zealand. Everyone is equal under the law, and the Crown, the government, has the right to rule. Now, what the announcement last week said, the three items of the announcement last week, one was the government has the right to rule, no problem. Number three was everyone has equal rights, no problem. We agree with both of those very strongly. The problem arose in the second article, so-called interpretation of the second article, which said the Crown recognised the rights that Hapu and iwi had when they signed the treaty. The Crown will respect and protect those rights. Then it says those rights are different from the rights everyone has a reasonable expectation to enjoy. In other words, everyone has the same rights, only when they are specified in legislation, treaty settlements, or other agreement with the Crown. In other words, the implication is that the Crown, the Parliament, can legislate, has legislated in the past and may in the future, for different rights for some New Zealanders than others. And that's the clause we have a problem with, because it, to my mind, isn't consistent with the original description of this bill as David Seymour described it, nor indeed our interpretation of what the treaty originally said. So it's the second clause which we have difficulties with.
Okay, the Treaty of Waitangi Act, which you want to retain, Don, of 1975, and which I'd happily put in the junk bin of history. But the Treaty of Waitangi Act clearly says that both the English and the version and the Maori versions of provides Maori with particular rights, in contrast to those who are not Maori, does it not?
Well, My understanding is the interpretation. I can't talk to the 75 Act. I don't know that.
Well,
well
okay.
enough
Well, I
to
mean,
know.
can I take you to the second article, for example, of the English version of the treaty, which says, Her Majesty the Queen of England confirms and guarantees to the chiefs and tribes of New Zealand and to the respective families and individuals thereof the full, exclusive and undisturbed possessions of their lands and estates, forests, fisheries and other properties which they may collectively or individually possess so long as it's their wish and desire to retain the same. At that stage, are you suggesting that that doesn't give them particular rights that are different than...
No, of course not. It simply says the property you own is yours. This treaty doesn't in any sense attempt to overturn the rights to property which you now have. And the fact that they're talking about property is confirmed by the second half of that article, which you didn't read out, which said, and you have the right to sell it under certain conditions. So they were clearly talking about assets which they had a right, which they did own, and therefore had a right to sell. Incidentally, the Maori version of the treaty doesn't refer to fisheries or forests, but that's
no,
been
it
added,
doesn't. It calls it te anga, which is a movable feast. It has to be said.
Yeah. Right. So,
but even if I was to take the English version, it would seem to me that it does treat. It's not just chiefs and tribes of New Zealand, but also respective families and individuals. Now, you're saying, oh, well, they own that land. But in many cases, if that land was taken from them after 1840, then surely they have had that legal right removed from them, haven't they?
Well, I mean, if land was taken as opposed to being sold, then recompense is appropriate. And, of course, that's the basis of the whole treaty settlement process. And I don't think anyone, or no, sorry, not anyone, there are very few people who say the treaty settlement process is wrong. When it can be established that property was taken as opposed to bought, then compensation should be paid. And we have no problem with that at all. It's true for any New Zealander. And I don't object to that. But as the wording of the treaty, Article 2 says now, you have property rights and you've got the right to sell that property. Well, I mean, that you would agree with that, so would I.
Okay. The legislation, treaty settlements or other agreements with the Crown basically means that Parliament's sovereign, doesn't it? So it says, well, we'll give you these special rights if we deem it democratically to be so, because only Parliament can do that through legislation, treaty settlements and other agreements with the Crown, yes?
Yeah, and it's somewhat bizarre because the wording of the current second article, which is the one we're talking about, of course, seems inconsistent with the third one, where it says everyone is equal before the law and is entitled to equal protection, equal benefit of the law without discrimination. So, I mean, how that particular clause got into it, I don't know, and I haven't got insider information on it. But it does seem quite bizarre and inconsistent with the third article. Okay.
But that's why we're trying to get some sort of sense out of something stupid. I mean, the whole idea that you're governed as a country in 2024, Don, by an 1840 document that's got Maori and English versions that mean different things to different people, it's just insanity. But
well, I can agree with that in some ways. But as I say, I don't have a problem. As the treaty has been interpreted from Maori to English by people like Sir Hugh Kaporau, who translated the treaty late towards the end of the 20th century. That translation, which is the one that, for example, Michael Bassett uses, and the Waitangi Tribunal used when he was on the Waitangi Tribunal, seems to me to be pretty inoffensive. You've got property, you've got a right to sell it.
Yep. Now, what's happened to the Kafaru translation?
I can't answer that question. But I mean, my understanding
why has it fallen out of? Yes, but why has it fallen out of favour?
Favour. Yeah, I don't know. But clearly, because it interprets the treaty in the way that we have interpreted it for 150 years, until 1987 anyway, maybe activists decided that wasn't a good translation. They want a different translation. I mean, it is bizarre to my mind. The clear wording of the treaty seems to make it abundantly clear in both Te Reo and English that the Crown has the right to govern, you have property, you've got the right to sell it, and everyone's equal under the law. I can't object to those principles, and no one else that I can think of should object to those principles. If you do object to that, you want some special rights for those who chance to have one Maori ancestor, and that's bonkers.